Subscribe to LearnCab and hit the bell icon to get notified.
Hello everyone, good evening. How are you all? I am CA Jala and I am the host of today's webinar. So let me introduce Ashish sir to all of you. Mr. Ashish Gupta is a honorable member of ICAI and ICSI. He is from Jhansi and has given training to 9,500 plus students across the country. He comes up here with a teaching experience of 11 years, enlightening law with a unique approach. He possesses in-depth knowledge and rich working experience in varied law subjects. He teaches to students of all stages of provisional governance and teaches law to IPCC and final students of ICAI. He has also been a visiting faculty in Rajkot, on the Gujarat and Jaipur. He has been a distinguished speaker on the platforms of ICAI and ICAI. Now, without further ado, I would like to hand it over to Ashish sir to detail everyone on the best strategy to study from section 241 and section 244. Over to you, sir.
Okay. Thank you, Jala. Thank you. So we are going to start the new concept. We are going to start section 241 and section 244. And both are the important section as far as examinations are concerned. These topics are means section 241 and section 245. These are the examiner's favorite topics. He will definitely ask a 5 marks question from these two sections only. So for securing the 5 marks, you just need to understand the section 241 and section 244 of the Companies Act 2013. Now, before moving towards this section, we should know the purpose. What is the purpose behind this operation mismanagement concept that to be introduced by the Companies Act either 1956 or 2013? So, what is the meaning of operations and what is the meaning of mismanagement? Right? We can call as a operations. It means that majority members are doing some act and which is not beneficial for the minority member. So before going towards the section 241 and section 244, first we need to understand the definition of member. So basically this section in section 241 and section 244, this provide the protection to the members only. It means a director or any other person related to the company, they are not eligible to file an application before the NCLT to claim relief under section 241 and section 244. This is the prerequisite. So before going towards the section 241, 244, first we will understand who is the member. So for going to the member, we need to refer the section 2 clause 55. It deals with the definition of member and it tells about a person shall be a member of the company if he fulfills two criteria, if he fulfills two concepts or conditions. First one, he agrees in writing to become a member of the company. Means that person should be a member of the company and his name is entered in the register of member. This is the most important point, right? The person who is going to apply to the NCLT to claim the relief under the section, he should be a member of the company, first thing, and his name should be entered in the register of member of the company. Now, what is the register of member? So register of member is a register which is maintained by a company, either an unlisted company or a private company or a public company. They need to maintain a register of member. In case of listed company, for the purpose of making the register, this process delegate to the depository part. So depository are the intermediaries who are going to maintain that register. So this is the definition of member as per section 2 clause 55. So if any person wants to claim a relief under the section of 241 and 244, first of all, he should be a member only. Then only he can prefer an appeal to the NCLT to claim a relief under this section. Now we will start the section 241. Right. So there are two sections, 241 and section 244, and this is the most important section as far as examination is concerned. Now, what is the logic behind the section? Law clearly specifies like section 241 and section 244. Section 241 talks about application to tribunal, right? You need to make a application to tribunal to claim relief in case of operation and mismanagement. Now, Section 241 prescribes the grounds. Section 241 prescribes the grounds under which grounds you can make an application to the tribunal. For this, you can relief in case of operation or mismanagement. And a single person is not eligible to make an application. So for this, Section 244 is prescribed. It means Section 244 prescribed a certain number of members who are eligible to make an application under Section 241 before the tribunal. And the tribunal means NCLT. Now, the first point, who can make an application? So we already gone through the definition. Any member of a company, right? He have some issue, he will make a complaint. And what complaint he can make? So he will make a complaint that company existing members are making some decisions which are prejudicial to the interest of the company. So first point is, any member of a company, they will make a complaint. And what they will make? That the affairs of the company, mean the working of the company which are conducted by the directors or majority of the members, is prejudicial to the public interest or interest of the company. So this is the first point. Member need to make a complaint to the NCLT and complain with respect to affairs of the company or any member or interest of the company. Now, one thing is more important. Member is not in a position to make a complaint that company is not providing dividends, right? We will later on we will discuss the practical questions, and under this question one member will complain to the NCLT that in spite of the fact that company is earning huge profit, then too board of director is not declaring dividend, whether this amounts to operation. So law clearly specify that this will not amount to operation. This is not at all prejudicial to any member. So first point is any member of a company. Second point, and any member of a company, they can make a complaint to NCLT for the purpose of prejudicial to the public interest. Now, suppose for example, if there is a material change and material change takes place in the board of director of the company, BOD of the company, or in the management of the control. So if there is any material change, like say for example, there is a Mr. A and Mr. B, both are independent director or both are ordinary director, but they are working very fantastically. Now, other member wants to remove such director, that this is called as a material change. So if there is any material change, then also we can make an application to the NCLT, means tribunal, for claiming relief in case of operation and mismanagement, right? And for this claiming relief, you need to such number of members can apply as are specified under Section 244. If you will ask us which is the most important section, either 241 or 244, so I will go for the 244. 244 is the most important section because that section prescribes like certain number of members who can apply for the purpose of operation to claim a relief before the tribunal. So this is our first slide which talks about the two parts. Any member of the company can apply and he can pray before the NCLT that the affairs of the company are being conducted in a prejudicial manner, or there is a change in the management of the control, or there is a change in the BOD which may indirectly affect to our company. And who are the members who can apply? So that number of member is prescribed under Section 244, right? So this is the concept which we need to understand most importantly. Now, Section 241 talks about this part only. Now, there are 2 to 3 more issues which we can discuss in Section 241, and that issues with respect to subsection 2, central government, right? In the opinion of central government. So in the first subsection part, we gone through the member who can make an appeal to the NCLT or for the working of the company or the for the change in the BOD. Now, subsection 2 talks about that central government, right? So they are going to use the word central government, that in the opinion of central government, if there are some circumstances exist. First point, And what are the circumstances exist? Like any person conduct in the members of the company, like any person conduct concerned in the conduct or member of the affairs of the company, and that person is doing business of the company which is not sound business principle. He is not following the prudent business activity. What a normal person can doing, right? For doing a business, you need to follow the certain ground rules. You need to comply the certain rules. So he need to, in the opinion of central government, so central government can also provide relief under section 241 if he is satisfied that any person concerned in the conduct or member of the affairs of the company, he can issue a direction to claim the relief. Second point, the business of the company is not conducted as per the sound business principle, means what a businessman can follow his principles while doing any business that is not followed by any person. So these are called as a sound business principles or prudent commercial practice. This is the second point. Now, the third point talks about the with respect to company is or has been conducted by any person. And if the person is going to conduct the business that will cause a serious or damage effect to the interest of trade or business or industries, right? So this is the third point. First point talks about the member part. Second point talks about the central government part. And third point talks about that the person he is doing business that will affect the entire industry, that will affect the business of the trade. He can make an application to the NCLT to claim the relief against such act. The business of the company is conducted the main intention to cheat the creditors, to defraud the creditors or member. So in that case, central government has a power that they can initiate a case, they can file a suit against such person, and afterwards they will refer that person to the tribunal with a request that the tribunal may inquire a case for making any request to the tribunal to initiate an action against such default, either is prescribed by a member or by central government or by any person or the person who is defrauding the creditors. You need to provide a statement. You need to provide a logic that what is the reason behind this. In the point B, we talked about the material change. Now, what is material change? So in the next slide, you will learn to understand that there is an alteration in the company board of director. What is material change, right? That there is an alteration in the company BOD, or there is an alteration in manager, or there is an alteration in shares of the company, right? The ownership of the company. So in all the cases, this is treated as a material change. And with this material change, you can apply to the NCLT. You can apply to the NCLT to claim relief against such operations, right? Now, in this provision under section 241, there is a famous case law, so-called Foss versus Harbottle, which is mentioned there. So that talks about that a majority, if there is some act which is done by the majority shareholder, and this is operational, this is prejudicial. So minority can file an application before the NCLT by proving the circumstances mentioned under section 241 to claim a relief. Now the question arises, can majority member claim relief under section 241? So by going to the language of section 241, it is nowhere restricted that only minority member can claim relief. Even majority member can also claim relief under this section also. So section 241 neither disentitled a majority of member to make application, nor require the application shall be made by the minority member only. So in the examiner will ask a simple straightforward question, like suppose there are 100 members, 70 members, or we can say 60 members are in majority, 40 members in minority. Now, to claim the relief, majority members wants to make an application to the NCLT for claiming relief. What is your answer? Whether the majority member are eligible to make an application? Yes, you need to make that point that in section 241, nowhere there is a restriction to apply under section 241 by majority shareholder, means that majority shareholder can also apply to the NCLT, right? This is the first point. Since Section 241 is of a remedial nature. Now, remedial nature means object of the Section 241 is to prevent mischief. And what is mischief? Mischief is wrongful act of any person to gain any advantage over the other, right? So this is the meaning of mischief. So the basic intention for introduction of 241 is to prevent the mischief. So that mischief can be done by a minority member, can be done by the majority member. So we can conclude that Section 241 remedy is majority member also. An application made by the majority shareholder alleging operation of mismanagement is not a prima facie invalid. It means you are not supposed to disentitle any majority shareholder. This is the most important point. Later on, that will be majority member needs to prove. Like on what ground they are making that application to claim a relief against the minority shareholder. For this, they need to make a valid statement. They need to provide the facts. But as far as application is concerned, before the NCLT, it is nowhere mentioned under the Act that they are disentitled to make an application under Section 241. Now, there are certain points also. The facts and circumstances may justify the intervention of the tribunal. Remember, tribunal has a discretionary power, right? So they can use that discretionary power. The tribunal intervenes if the majority proves that. If the majority proves that there is a sufficient ground to constitute operations on the majority, means majority needs to prove that there is a specific fact, there are specific grounds on which we are going to claim the relief against the act of minority members. Thus, where the fact proved harassment of management by forming parallel board of directors, maybe there is a possibility that minority members himself constituted a parallel board of directors, or they are conducting parallel board meeting, they are conducting parallel AGM or parallel registered office. That all situations will lead to the operation part. And majority member can entitled to make an application, and this is a valid case law as decided in Sindhi Iron Foundry Private Limited, Radhe versus Ashish Gupta and Kamal Oil Mills, right? So this is the point, that majority members can also make an application. So this is overall Section 241, which talks about that in what situations, under what circumstances, under what condition a majority member, a minority member can make an application to the NCLT to claim the relief under Section 241 or 244. Now, before starting 244, remember always one thing. For claiming relief by the member, there is only this section provides, means 241, 244 provides relief to exclusive to members only. What is the meaning of member? We already gone through the definition. Section 2, clause 55. The member is a person who is willing to himself nominate as a member, means he bought the shares of the company and his name is mentioned in the register of member. Now, my question is, member will include only equity shares or preference shares? There is a definition prescribed under the law. Section 2, clause 55, they have prescribed the definition of member. So whether the counting of member, like how many number of members are entitled to make an application under Section 241, and that number is specified under Section 244. Like suppose for example 100 members. So whether that 100 member include only equity shares or preference share, this is my question. So you need not to apply your mind, you just need to remember that word member. Member is a person, either he can be an equity shareholder or he can be a preference shareholder. The person is qualified to be a member as per Section 2, clause 55. He is treated as a member and he is eligible to make an application. Now, who are the members eligible to make an application under Section 241, and eligible member condition is prescribed under Section 244. They have divided the whole eligibility criteria into two parts: a company having share capital, a company not having share capital, right? So a company having share capital, they have prescribed a 3 criteria for eligible member. Like 100 members can apply. 100 members can apply so that under section 241 to claim a relief. And that 100 members can be a preference shareholder, can be a equity shareholder, or can be both. Both also can apply. This is the first point. Second, 1/10 of the total number of members. Now remember one thing. 1/10 of the total number of members. Suppose, for example, in our company there are only 200 members. And out of these 200 members, only 40 members applied under section 241. Now, you need to answer whether this application can be maintainable as per section 244 or not. So for answer this question, you need to go through the provision part. What is mentioned? 100 members. So this will not fall under this condition. And second is 1/10 of total number of member, and total number of member is 200. We will take out the 1/10, that comes to 20. Out of the 200 members, 40 member have applied under section 241. So they are eligible shareholder. They can validly apply before the tribunal. Third point, and with respect to capital part. First 2 points talks about the member part, right? Like member who are eligible to make an application. Third part talks about the share capital part, and this is the most important part. What they have mentioned, member holding not less than 1/10 of the issued share capital of the company. Now the most important keyword under this point is issued share capital of the company. You very well know in the IPC examination, like there is a authorized capital, there is a paid up capital, there is a issued capital, there is a subscribed capital, but you need to forget all this capital. Just you need to remember that specific word, issued share capital. Examiner will provide you authorized capital, he will provide you paid up capital, he will provide you subscribed capital, and he wants that you should be confused, like which capital you need to take out the 1/10 of the share. So for this you need to remember this is the issued share capital. One more thing, that in each and every provision, in other provisions of the companies Act, generally you will find paid up share capital. But under the section 244, this is not paid up share capital. They have got issued share capital, means they are providing the rights to the shareholder also, those who have not paid the full capital. They have not paid the share capital of the company to the company. In fact, they have subscribed the shares. Like company have issued the shares. So you need to take 1/10 of issued share capital. Again, it can be equity or it can be preference. So for company having share capital, you need to decide applicability part from a 3 criteria. First 2 criteria depends on the number of member part. Last criteria depends on the issued share capital part. This is the important point. Now, suppose for example my company, means in the examination you need to check whatever is provided. They will provide the number of members, they will provide the capital, and simple they will ask in the bottom of your question, like whether the member are eligible to make an application as per section 244 under section 241. So for this you need to apply your mind. You need to check via member part, via share capital part, and that share capital is a issued share capital. Now move towards the next part, that is not having share capital. Now there is a simple, they have provided a simple one concept only. If your company does not have any share capital, means a company without share capital, in that case 1/5 of the total number of member is eligible to make an application under section 241. This is the most important point, right? Suppose this is the first slide of section 244. Now for example, 100 members are required to make an application under section 244 in case of company having share capital. What if number of member applied is 99? Examiner will ask a simple question on this, like in case of ABC Limited, some members, minority members are treated as a prejudicial, that certain members, maximum majority members are doing some act and that act is prejudicial to their interest. In that case, what they will prescribe? Like 99 members make an application and they will provide there are 1200 members, and out of this only 99 members make an application. You will calculate like 1200 members and suppose for example out of this 100 members required minimum, 99 members applied, so there is a deficiency of only one member. So you will directly go towards the answer that members are not eligible to make an application under section 244. But in the second slide, what they have mentioned under section 244, like tribunal may entertain an application. What they have word used, may, means this is the discretion of the tribunal. They have not prescribed any kind of rules like a tribunal should entertain. What they have mentioned, tribunal may entertain any application if number of members are less than as required by law. It means as per section 244 number of members. So in the examination, if they ask a simple question like there are 1200 members and like this and like this, and they will mention that 99 members made an application to claim a relief under section 241. Now decide as per the relevant provision of Companies Act whether such member are eligible to make an application or not. So what we will do, what we will write in the answer part. So first we will write like as per section 244, these are the certain prescribed criteria. Criteria means 100 members or 1/10 of the member or 1/10 of the issued share capital. Now in the second point, in the last point, in the concluding point, we will mention, however, there are 99 members and required number of member is 100. Tribunal may entertain an application if the number of members are less than as required by law. This is the most important point. Now some extra shots. What if concept, examiner, these are the examiner first point. First point, where any shares held by two or more persons jointly, whether they will count under this concept of one or not. Suppose for example, there is a husband wife, Mr. A and Mrs. A, right? Mr. A and Mrs. A, both are holding only one share. Both are holding only one share. So for the purpose of counting total number of member as per section 244, we will count Mr. A and Mrs. A as a one person or a two person. So for this, law has provided an answer that they shall be counted only as a one member. In spite of that fact, these are the specific two natural person. If they are holding one share jointly, means they are holding shares jointly. For this, you need to count them as a single person. This is the first point. Second, suppose for example there are 100 members. Now who will make an application? All the 100 members will go to the NCLT office and make an application and sign thereby in a line. They will make a queue and they will sign one by one. No. So law has provided any one member make an application on behalf of others. Right? It is not necessary that all the members should be present before the NCLT. Means any one member, he can himself appointed as a nominee, something like that, and he can make an application on behalf of other under section 241. Now some other points. First point, where shares are held in a demat form. Demat form means depository system. And what is depository system? In case of listed company or companies who are going to be a proposed listed, they need to compulsory convert their physical shares into demat form, and this is the most important point. Now what is depository system, right? There are two kind of depository. There is an act called Depository Act 1996. So there are two kind of depository in India. First is CDSL, that is called Central Depository Services Limited, and there is a NSDL, National Securities Depository Limited. What is the function of these depository? They are going to convert the physical shares into e-form, electronic form. So in case of listed company where the shares are held in a depository system, the beneficial owner, remember one thing, in case of depository system, the name, your name, suppose for example, I am holding the shares of the Reliance Limited. Now, shares will not held in my name. I am the beneficial owner of such share, right? I am the beneficial owner of the share. So, who will be treated as a member? So, law has provided that beneficial owner is treated as a member in case of depository system, because in the register of member of Reliance Limited, the name of two depositories will mention CDSL and NSDL. So for the purpose of clarity, they have mentioned like the beneficial owner will be treated as a member of for the making application under section 244. So this is the first point. Second point, a person entitled to share but whose name has not been entered in the register of member cannot apply. Now this is the most important point. And this point can be arises via any situation. And what is the relevant situation? Suppose for example, there is a Mr. A and Mr. A dies. In that case, that his son, that is called proposed nominee, should enter his name or transfer his father's share in his own name. So in this situation, a person entitled to share that he is the only son of Mr. A. He is purely entitled, but as of now, while making the application under section 241, his name is not entered in the register of member. So law has clearly specified a person entitled to share but whose name has not been entered in the register of member is not eligible to make an application under section 241. And what is the logic behind this? Like you can refer the definition section 2 clause 55, right? Members definition. The second point we clearly gone through, like a person is named in the register of members. So this is the second point. Now there may be a different situation also. Third case, suppose for example a person applied to a court. In the last example, like Mr. A dies. In that case, Mr. B, the son of the Mr. A, he applied for the purpose of nomination of such share, transfer of such share or transmission of such share. In that case, he applied to a court to obtain a judgment in his favor. We can call it as a decree. Like his father's name should be removed and his name should be entered before this number of shares. In that case, court provided a decree. This is the important point, right? Court provided a decree in favor of Mr. B, son of Mr. A. In spite of that fact, his name is not entered in the register of member. Now the question arises whether Mr. B entitled to make an application under section 241, 244, whether he will be counted or not. So this point is most important. This is the different kind of answer. And you need to remember this point. This is decided in the case law. So what they have mentioned, where a person has obtained a decree, and what is the meaning of decree? Judgment in your favor. As per the Civil Procedure Code 1908, for rectification of register of member of the company to have his name entered in it, right? He may make an application, although he is not a member as per the, because his name is not yet entered in the register of member. Then too, he obtained a court decree. He will send a court decree to the company. Company will rectify register. Right now, company have not yet updated their register. Then too, he can make an application. He will be treated as an eligible shareholder. Fourth point. A person whose favor share certificate have been issued can exercise the right as a member, notwithstanding the omission of his name from the register of member. For example, I transferred my shares to Mr. Z by today only, and by tomorrow we are going to apply for claiming relief under section 241. In that case, my shares will get transferred to Mr. Z by say for example by 1 week later. In that case, whether Mr. A, whether I am eligible to make an application? Yes, I am perfectly eligible to make an application because I am the member of the company. My name is entered in the register of member. Both the conditions I have fulfilled as per section 2 clause 55. Then also I am eligible to make an application, right? So these are the certain points. There are more extra shots which we need to remember while answering our examination. So in the next slide, the requirement of minimum shareholding. This is the most important, and you need to make a underline of this one. Like whatever minimum number of members, like say for example, in case of company having share capital, 100 number of members required, 1/10 of number of members required, or 1/10 of issued share capital. The members holding 1/10 of issued share capital are eligible to make an application under section 241 will be counted under section 244. Now, so that number of member 100 is required. Suppose for example, Mr. A along with the 99 members, they all applied to the NCLT for the purpose to claim relief under section 241. Right now, by some incident, Mr. A expired. Now the number of member can comes to 99 on, say for example, after 2 days, or some for example like 4 to 5% expired. Now in that case, so what the law have mentioned, that the requirement of minimum shareholding that should be qualified at the time of making the application, only at the time of filing of the application. Later on, that member reduced to below 100, it will not affect your application validity. Your application is absolutely valid. You need not to worry for that. So what they have mentioned, the requirement of the minimum shareholdings to be satisfied only at the time of filing of application. Examiner will provide a fantastic case study. Like on say for example 1st January, by making the application, there are 102 members. Out of this 5 member disappeared. Out of this 3 members found dead, like something like that. So you need not to worry for this. Your answer should be pinpoint. Like we need to satisfy the requirement of minimum number of member as specified under section 244 at the time of filing of application. This is the most important concept. If some of the member who consented to the application cease to be the member, means they sold their shares to the other person, then too your application is still maintainable. Where after making the application, the applicant name was struck from the register of member. In the second point, in the register of member, on the ground that transfer was made unstamped or because of any other reason, still your application is valid. This is the most important point. Whatever requirement of member, you need to comply. You need to comply at the time of making the application. In spite of that fact, later on what will happen, that will not affect the validity of your application. And this is the most important point. Some other points more. Like for example, in the next slide, the applicant must have paid all the calls and other sum due on their shares. However, there is a discretion available to the tribunal that they can waive this requirement. That is, tribunal may permit filing of application even when the calls or other sum due on the shares have not been paid. So you need to take a assumption for the in the examination part, right? So last point, in section 244 requires that application should be made by the requisite number of member. It does not require that the member must be a holder of equity shareholder. We already discussed this point under section 241 itself. If you are a member, you are eligible to make an application. That will not affect any validity of your application, whether you are an equity shareholder or you are a preference shareholder, right? So these are the certain extra shots which you need to remember in an examination part, because examiner is not going to ask the direct question from the provision part. He will use that part along with the provision part in your examination question, right? So these are the important points with respect to section 244. Now, in the next slide, we will discuss some examination questions part, right? The first question starts with like shareholder consisting of a group of shareholder consisting of 30 members decided to file a petition before the tribunal for relief against operation mismanagement by the BOD of Messrs. Amrapali Manufacturing Company Limited, having a paid up share capital of 1 crore. How many number of members decided? 30 members, right? And the paid up share capital of 1 crore. Okay. The company has a total of 500 member. How many total number of members? 500. Okay, so we will do the rough calculation in our mind, like 500 members are there, minimum required is 100 or 1/10 of total, so it comes to 50. Okay, let's move forward. The group of 30 members hold 1/10 of the total and they have used the word paid up share capital. Accounting for, remember one thing, right, that we need to consider the issued 1/5 of the issued share capital, means the 30% holding 1/10 of the paid up share capital, but 1/10 of the paid up, it means they are holding 1/5 of the issued share capital. So for our consideration, for our examination, for our answering part, we are not bothering about the issued share capital. We will consider only the 1/5, or sorry, we are not concerned for the paid up capital. We are only concerned for the issued share capital. That is 1/5 and required is 1/10. Okay. The grievance of the group is that due to the mismanagement by the board, the company is incurring losses and has not declared any dividend. Okay. So they are not going to erase that point dividend, because dividend is not a kind of any operation. This is not a prejudicial interest to any member, because as far as this provision is concerned, dividend, how much dividend should be declared, this is the purely discretion of the directors only. Okay. For the past 5 years, in the light of the provision of Companies Act 2013, please advise the group of shareholders regarding the admission of petition and the relief thereof. Now remember one thing, 1/5 of the issued share capital and they have 30 member applied. Okay, so first we will calculate the part in section 244. So in the next slide there is a hint provision which prescribes the 244 provision. Like 244, 50 members we need to require to make an application. In the question only 30 members eligible, so we did not fulfill that condition. One or more member holding 1/10 of the issued share capital, so we are not in a position to fulfill both the condition. Now this is the hint 1, and there is a hint 2 which talks about the, in the instance case a group of 30 members have made an application to the tribunal which is less than 15 number, and also they are holding 1/10 less than 1/10 of the issued share capital. Thus, the said group of shareholder does not meet any of the above criteria. However, discretion, there is a discretion available to the tribunal, like they can allow that person to make an application. Thus, members may approach the tribunal to permit them to make an application. Now remember one thing, in the question number 1, like group Amrapali group, like we will decide as per section 244. So 244, we need to check out the requirement of minimum number of member, or they are holding the minimum issued share capital. In that case, we need to check the both the condition. If that fulfills also, then too, if the members have any issue with respect to dividend part, that board of directors are earning huge profit, then too they are not declaring a dividend. So remember one thing, tribunal will definitely reject the application later on of these members only, but we are not going to consider this one. We just need to refer the section 244 whether the application is maintainable or not. Later on that tribunal will reject, this is a different kind of concept. If in the same question they will ask whether the concept of whether the non-declaration of dividend amounts to operation, then we will definitely mention that will not amount to operation part. Question number 2. The issued, subscribed, paid up capital. Now they have mentioned all the capital of Z Limited, that is 10 lakhs, consisting of 90,000 equity share of rupees 10 each, fully paid up. 10,000 preference share of 10 rupees each, fully paid up out of the member of the company. 400 member holding preference shares, right? Out of the total number of members, there are 400 members who are holding preference share, and 50 member holding equity shares applied for relief. So there are 400 members holding preference shares, and there are 50 members holding 500 equity shares. So 400 plus 50, so there are total 450 members applied, right? Now for claiming relief, As on the date of petition, the company had 600 equity shareholder and 5,000 preference shareholder. Examine whether the above petition is maintainable or not. So we need to do the calculation part whether okay, later on there is a second question also. Will your answer be different if preference shareholder have subsequently withdraw their consent? So while answering this question, first we will present the case. And what is the case? As provided in the hint answer slide. In the first present case, the shareholding pattern of the company is as follows. Equity share capital is 9 lakh, which is held by 600 members. Preference share capital is 1 lakh, holding by 5,000 members. So total share capital is 10 lakh, which is holding by 5,600 members. Now, in the next slide, the application alleging operation mismanagement need to be made by preference shareholder 500 members, 50 equity shareholder, total is 450. Okay, so amount of share capital they hold, like preference share capital rupees 4,000, 400 preference shares into 10, rupees 5,000 equity share capital, 500 equity shares into 10. So the total share capital they all are holding is 9,000, right? So we need to present the answer in a such way, like we need to calculate total number of members. We need to calculate total number of equity share also. The application shall be valid. Now we will provide in a graded manner. Like for example, 100 members, okay. 560 member, 560 comes to 1/10 of 5600, and members holding 1/10 of 10 lakh, that is called 1 lakh. Right? So in that case, hint case, it is evident, right? The application made by 450 member and that fulfills the criteria specified 244. Hence, our application to claim a relief is maintainable. Applying the judgment given in the given case, the petition made by the shareholder shall remain valid despite the fact that some of the petitioner have withdrawn their consent. It does not affect the validity of the application. Whenever they make an application at the time, so we need to take care that 244 number of member present, 244 holding of present should be at the time of making the application only. So comment, it has been assumed that the member holding making the application have paid up all the shares on their capital. So this is the answer of this question number 2. Now there is a question 3, and this is the good question. Legal representative of a deceased member of a company alleged operational mismanagement. He made a complaint to the tribunal for relief under section 241. The management of the company is of the opinion that petitioner has no locus standi, means he is not the member of the company, so he is not eligible to make an application. The register still shows the name of the deceased as a member. Register of member still contains the name of the deceased member. Will the representation be entertained by the tribunal? So, hint answer, the legal representative of a deceased member is eligible to file a petition under section 241 to claim a relief against the operations and mismanagement, even though his name is not appeared in the register of member. It would be wrong to insert the name of the, obviously later on that his name will be entered. If he approaches to the court, then to court will provide a favor in his decision. So that's why they have mentioned it would be wrong to insist that name of the LR should be to put first on the register before he can make an application under section 241. Therefore, the tribunal may entertain the complaint in the given case, right? So this is the answer of this question. Like if in case of LR case, in case of deceased shareholder, LR is also eligible to make an application under section 241, under section 244. In spite of that fact, his name is not entered in the register of member. Next question. Messrs. Sunshine Oils Limited, right? This is the last question of our discussion. Messrs. Sunshine Oil Limited, a listed company as of 31st March 2018. As per the audited financial statement, is having 200 depositor with 50 crores of deposit in the company. Out of the total 200 depositor, 20 depositor have formed a group. have formed a group and have appointed Mr. Ram, a practicing advocate who is not the member of the depositor, and that section belongs to section 245, right? So this question is at all not at relevant for this discussion, and that question 4 belongs to section 245, which talks about the class meeting, right? So this is the overall concept, this is the overall discussion of section 241 and section 244. We will somewhere later on, we will in another webinar, we will discuss the question 4 part, that is section 245. So we will end up with this topic that is called section 241 and section 244. And remember one thing, before doing director's part, before doing SEBI part, before doing FEMA or something like that, you first need to start your company law syllabus with section 241 and section 244, because this will provide you sure shot 5 marks in the examination, because whatever there may be a tricky situation our examiner can involve, we already covered all the points which he can indulge in the examination part. So as far as section 241 and section 244 discussion, this is all from my side. If you have any question, you can directly ask a simple question, right?
Sir, one student is asking why LR have right to file petition since he is not a member.
Correct. So as per section 255, a person should be a member, then only he can make an application under section 241 or 244, right? So if we are specifically talking why LR is eligible, by default he is eligible to make an application in spite of the fact that his name is not entered in the register of member. The reason is simple, that LR is the person who is eligible to take the shares, who is eligible to transfer that share in his own name after the death of the deceased member. So suppose for example, if he approaches to the court, then also after verifying all the documents, remember one thing, for transferring shares of the company will also verify the eligibility of the nominee. Now in that case, suppose for example there are all the documents which are available with the nominee, or we can say LR, these are the valid documents. So if he approaches to the court, so court will also provide that he should be a true LR, he is eligible, that his name should be entered in the register of member. So this is the reason that LR is eligible to make an application, provided he need to prove that he is a qualifying LR for this purpose. Suppose for example there are 10 sons of Mr. A. Let's take a worst case scenario, right? In that case, all are not eligible to make an application. All will be counted as a single person. All are not eligible to make an application. Obviously, there may be some court decisions in that case. But we are talking for there is a single person, Mr. A, and who is a deceased member, and there is a Mr. B, who is the son of Mr. A. In that case, in spite of the fact his name is not entered, because anyhow Mr. A will not come back, and Mr. B is having all the requisite document for the purpose of transfer of shares. So that is the case that he is entitled by default to make an application under section 241 in spite of the fact his name is not entered in the register of member. There is a next question is like what is a material change? Now material change, say for example there is a director called Ratan Tata, right, in a company. And there are some other directors who are involved in the company, and they are going to remove that qualifying person, or they are going to remove that founder of that group. We all made an investment, we all made a shareholder put their money by name of the Ratan Tata, the person who is actually involved in the company, right? So this is the reason, and some persons are doing malified act and they are going to remove that person. So this will be treated as a material change. That there is a totally termination of board director. So this is the point that will be treated as an operation mismanagement, right? Suppose for example, let's take a different example. As far as Reliance is concerned, we just stuck the name of the Mukesh Ambani, right? Later on we will remember the word of Nita Ambani, but first of all we will stuck with the name of the Mukesh Ambani. Now suppose we all invested in the Reliance due to Mukesh Ambani, neither of the Tina Ambani or Anil Ambani. Suppose for example Anil Ambani again started some new company, we are not going to invest because we know the hobby of Mr. Anil Ambani, right? But we are going to invest in a different company, if any, formed by the Mukesh Ambani, because that person having the approach And we are investing in the approach of a company. We are not investing in the business of the company, right? Approach of the person who is going to involve. So this is the material change that will be treated as a material change. This is the basic point.
Subscribe to LearnCab and hit the bell icon to get notified.